Thank you so much for this opportunity to be here this morning. And we'll try and answer some different questions, starting with what is a nice girl from Cleveland doing following a sophisticated European. I think it's just a telltale sign of how quickly all of our work, whether it's in private practice, where I originally came from, on the legal side, of course, or on the regulatory side, that we no longer can think about borders the way they are traditionally set up. And I really found one of Federico's mentions or statements to be so true of everything that we're doing and why the PCAOB even has an international program. And that's a question I'm going to try and answer for you today. But that is the fact that differences can't be smoothed over. It won't work if we try and do that, both from a business perspective, but as a regulator as well, looking at business and the conduct of business. And so a lot of what we're doing 10 years in from Sarbanes-Oxley is building the relationships with our counterparts and regulators in other parts of the world to figure out what is the most effective way from an investor protection standpoint to be able to work together, knowing that we are going to continue to have differences in our approaches, both for historic reasons, cultural reasons, language, a myriad, but that we actually can take great strength from that. So let me walk you through big picture, where we're at and what we're thinking about, and then open up for questions, because I think the most valuable thing I can do is try and answer what is on your mind. First, I have to make a disclaimer that these views I express today are my own and not necessarily the board. And indeed, in the international arena, there are going to be a series of decisions that the PCAOB, the board itself, is going to need to make over international cooperation, in particular in the areas of inspections. And so we are already actively working with them to lay the groundwork for that. And indeed, our greatest activity this fall in particular, and I'm just coming off an 8-week period where I spend 1 week in Europe, 1 week home, 1 week in Europe, 1 week home. But that is just a telltale, and I am one of 5 of us working with different member states in the EU as well as Switzerland. And all of us have been this active. And I think that, again, sort of 10 years in, if you take 10 years in from Sarbanes-Oxley, that's the US point of view, it's essentially a decade into the shift away from peer review. And a lot of the compare and contrast that I'm going to do is with Europe. I also include Switzerland in that because they did have their own reforms at the same time. And you also can't forget countries like Australia and otherwise. So we are all taking stock at this point. And now that we're sort of up and running as independent regulators, what does it mean for us to actually work together in an efficient manner? So just by way of background, as a reminder, we were set up to audit. We have a narrower mandate than many of our counterparts because we only, the only firms that have to register with us are the ones working on issuers. Now, of course, there's our new foray into broker-dealer regulation. I'm going to mainly focus on publicly traded companies. And some of the key decisions, of course, shift from peer review, but that no board members could be practicing members of the profession, and this is what I think was probably one of the most valuable decisions made by legislatures at the point in time when they had to decide what was really important. One of the key ones was our funding mechanism. We see fellow audit regulators struggle because they do not have a funding mechanism which is independent from the profession and the pressures from the profession. And second of all, isn't subject to sort of political whim year after year. So I think that a number of us, and we're not the only ones, there are other regulators who have solid funding mechanisms, but those of us who do are trying to support those who don't and who really can't fulfill their mandate without it. This is an interesting shift or sign in the Commission's proposals for reforms in Europe, because there's two parts to it. And I'll go into this in more depth, but there's two kinds of legislation. Well, there's more, but there's two key kinds. One is a directive, which you heard Federico talk about, where legislation is passed at the European level, but it has to be implemented with national legislation in the member state. And so you can have a divergence in approach. A second, to many member states, more heavy-handed approach is what's called a regulation, which means that the European level law becomes law in the member state, period, end of point. It's not for the member state to actually enact. And one of the Commission proposals in their revising their directive on audit, which is what we call the 8th directive, think of it as Sarbanes-Oxley for the PCAOB equivalents or the POBs in Europe, is to shift away or to shift towards our model in some ways. In the board members could not be, right now in Europe, a minority of an oversight board can be practicing professionals. The Commission would eliminate that. They also would be clearer about that funding had to be independent from the profession. And then a third part also is that there are some POBs now who rely on national chambers or institutes, AICPA equivalents, to conduct inspections with a layer of independent oversight. The Commission proposals would also eliminate that. Now, I say this knowing that there are also some of the European proposals are ones that we would learn from as well. There are ways in which, I just came from Spain, the independence requirements in Spain actually are far stronger than they are here in the US. So there are things that we, PCAOB, are learning from our European counterparts and other counterparts in the world. It's not a question of everybody coming to the Sarbanes-Oxley standard. Just very briefly, there are about 2,400 audit firms, US and non-US, registered with us. And of that 2,400, 900 are non-US firms from 84 different jurisdictions. That's our current stats. What we are seeing over time is originally a lot of firms registered with us either anticipating that they would get US issuer work or with small US issuer clients. So a small company within a jurisdiction couldn't really raise capital in their local home country market, and so they came to the US market. But over time, they have not really been able to sustain those listings. So you see those numbers going down. And then if you look on our website now, I really encourage you to go look, because we have revamped our list of registered firms in a way that you can sort by country, and you can sort by whether they actually are serving US issuers, which subjects them to our inspections, or if they're not. But we're trying to make that more transparent overall. So inspections of most non-US firms happen every 3 years because they usually have fewer than 100 US issuer clients. Why an international program? So our first really is investor protection. That is our key mandate. And when we look at the exposure and the market cap exposure for US investors, we would be derelict just to focus on activity here in the US. The market capitalization, this is a very conservative figure, But where we can separate out the U.S. market cap in a stock from world market cap, so what comes from listing here in the U.S. versus, let's take a Daimler-Benz, let's take a Siemens, that might be cross-listed. Sometimes it's difficult to delineate which is from the U.S. listing and which is from the overseas. Sometimes you can. But where our Office of Research and Analysis can do that, over $600 billion in market cap comes just from the U.S. listing. So these are foreign companies headquartered outside the U.S., but their listings here and the exposure for U.S. investors. Now, when we say U.S. investor, of course, that investor may be located in Switzerland. That investor may be located in China. It's particularly relevant in the U.S., and we often have to explain to our counterparts that we have a even more, or we have a focus on the individual investor because of the shift to 401k and defined contribution plans, and the exposure for individuals in their retirement savings that may not be true in the same form in other countries. Issuers and their auditors operate globally. So another driving force for us is the fact that global group audits are happening across borders and across teams. And so it's critical to know whether those teams actually are communicating well and that the group auditor knows what the component auditors are doing and the component auditor knows what is being asked of them. Because I do have to say, time and time again, what our inspection results are showing is that too many times they're at cross purposes. And so the component auditor will say, well, I did that, or the group auditor did that, and the group auditor will say, well, no, they did that, and in fact, nobody did it. Or they didn't do it according to the instructions, and there was no feedback channel to check that. So we are increasingly worried over and over, and other regulators are seeing this as well, that the group and component auditors are not talking to each other and working together in a way that ensures that the proper work, testing, coverage areas, high-risk identification is being done properly. It is also not consistently clear to investors who is performing the audit engagements and how much. So for instance, if it is a firm here in the US, but some 70% of the audit work is performed outside, whether you measure that by assets, whether you measure it by cash flows, whether you measure it by hours. Investors don't necessarily have that clear picture, and of course some of the debate right now about what should be in the audit report, who should sign, what should be identified, is getting at these questions. I talked a bit about a clear view on global group audits. When I come to a little bit of discussion of IFIAR, which I tend to think of as the UN of independent audit regulators, but it's us with our counterparts. This is a top issue. How can we, in an efficient manner, be sharing confidential information in a way that effectively gets a solid view on a group audit? And where is it that actually the networks, in particular, or whether it's a large formal network, whether it is a series of independent firms working together, where is it that they actually don't have the whole view? And then 10 years out, the cooperation among regulators 10 years out, in the transition from peer review, I think it's really a time of reflection on what's working, what's valuable, what's not. And so you see different jurisdictions in different manners thinking about that. South Africa right now is very actively most countries are thinking very hard about where should they put their inspection resources in the highest risk areas. A sophisticated regulator like the Swiss for instance, after a number of years of focusing on quality control, is now spending more time on looking at engagements, because that is where they actually can help the firms improve audit quality. South Africa, in the same way, has focused more on their inspection program on the larger firms, and found an alternative mechanism for ensuring that those firms working with SMEs in particular and short of audit are in solid ground. So some of our additional statistics. So I went through the 2375 firms registered. Sorry, that's not quite 2,400. 913 non-US, 84 countries. Almost 40% of firms registered with us are located outside the US. Almost 40%. Now, that's inflated somewhat by firms that don't actually do US issuer audit work. And so I think you're going to see that change. The board will grapple with that over the next couple of years. Approximately 25% of all registered non-US firms have at least one issuer client. And that triggers the inspection requirement, which means we go in every 3 years. Now, imagine when we go in every 3 years to look at a firm, we will never have the same intelligence, outlook, depth of understanding of that firm that the home country regulator has. Because the home country regulator, especially because the firms we're going in and inspecting outside the US tend to be the larger ones. So they are ones that the home country regulator with whom is very familiar. And so when we think about our cross-border inspections, we can't just think about checking the box and doing it the same way that we would do it here in the US. Instead, we have to think about how do we leverage the relationship with the home country regulator, take advantage of the knowledge that they have so that we can focus our resources in a complementary manner that works both for us and for them. We have had instances where, for instance, in joint inspections, because we can bring more manpower to the table and certain kinds of expertise, that they are able to cover difficult, complex issuer engagements they might not otherwise be able to cover. So that's value added for them. Value added for us, of course, is their expertise in their local market, their local firms, who's actually running the engagements. Registered non-US firms that play a substantial role or just referred work may be inspected periodically. They're not necessarily on a 3-year schedule. So here to give you a sense are countries with the most PCAOB registered firms. It's a bit idiosyncratic. India, for instance, very high number because of local restrictions on ownership and that you can only have small numbers, which of course was part of the issue or part of the reason Satyam and the fraud at Satyam and within the PwC firms there was harder to uncover. Satyam was a large moment of reflection for us. Because I think all of it, and I mean the PCAOB, but also other regulators. Because I think coming out of the box, everybody had to get themselves up and running. You know what it's like when you're a startup and you want to be able to work together. And then, whoa, something like Satyam happens where I really commend you to our website to see the enforcement proceedings and the final settlements in those matters. But essentially, Big Four firm, much of the fraud came down to the fact that confirmations from banks as to cash amounts were faked or just non-existent. So imagine all the questions. I think that was a moment when we said, oh, we can't just keep doing this alone. We can't just essentially close our eyes and say, oh, that's the other country, we're not going to go in there. And I think it opened up a number of regulators to seeing that the PCAOB was not necessarily just trying to regulate the world, but that there was a way, especially because we are younger regulators. We don't have a long storied history of, say, banking regulators that protect the crown jewels in a country. We have more flexibility to be leaders in a cooperative manner. So, and China, of course. So, here are the different countries where we've conducted inspections. For the most part, if you were to generalize, in the Americas, like the US, there aren't the kind of restrictions on cross-border regulatory activity. Europe is different, and I will come to that because of they have the EU, the 8th Directive, which prescribes the extent to which they can cooperate, and they have held out very strongly for what they view as reciprocity. What you have seen in the last 6 to 8 months is the dam has sort of broken, and we have come to understanding with the Europeans of what can work on both sides. And China will be the last. So, but we're hoping that Europe will set the example, that our ability to cooperate. This is a smaller subset of countries where we have actually done joint inspections, and that is going at the same time as the home country regulator. Now, when we do that, we don't just arrive boots on the ground, and we're learning more and more as we go. We have very heavy pre-planning in advance of the inspection, the teams getting to know each other, and choosing engagement selections together, focus areas, and learning about each other's. So you can be, for us as PCAOB, we can be in the Netherlands one day where the independence regulations are very different. It's really a threats and safeguards approach. And then you can be in Spain the next day where it's a prescriptive list. Which services can't be provided, which is a presumption that you can rebut, and then backed up by threats and safeguards. So, learning experience for us. We have a rule, it's called 4012, which allows the board to decide on a case-by-case basis whether to allow our inspectors or enforcement to rely on the work of a home country regulator. This really mattered to Europe. And I think as we were beginning in our, both of us in our first 5 years of existence, it took a while to understand what each other meant, what the Europeans meant by reciprocity and what we meant by reliance. Because they have a system, and again, this comes back to the differences that Federico mentions. They have a system where they make a decision that another regulatory regime is adequate, and after that point, then the EU member state regulators can rely on the work of that regulator. PCAOB approach, the US approach is very different. It's a case-by-case basis, depending on the circumstances. That can mean anything from the independence of the home country regulator to who has the resources. Now, where I personally see a model emerging you can find it online, there's a cooperative agreement between the Canadians and the Australian audit regulators. And it's a smorgasbord. It basically says, we're going to cooperate together to help fulfill our mandates. Now, by that point in time, understand they have different mandates. They have different jurisdiction over different things. So they have to they have to know those differences and they have to work them out. You can make a request for assistance, and then they decide what's the most appropriate. Is it that, country A will let country B come in and do an inspection and help facilitate it? Is it that the requested country will share information from their previous inspections? Is it that the home country regulator will do the work on behalf of the foreign regulator? Is it they'll do a joint inspection? It basically lays out the spectrum of potential cooperation depending on what the situation is, which comes back to what are the priorities, the risk profiles, and the mandates for the individual regulators. And that, I think, will in some ways be a model for the rest of us. But you have to have the will. These are some of the factors under Rule 4012 that our board looks at. And I think you will see our board making more decisions over the next 5 to 10 years as we all mature and get to know each other more closely and where we can depend and where it makes. This is about allocation of resources among regulators. So, for instance, if the market cap exposure is for a U.S. investor, it makes more sense for the PCAOB to spend the resources looking at that engagement. It does not make, from a financial standpoint, it does not make sense for the home country regulator to look at that if they're investors, i.e. who's paying their bills, to spend their resources and time on that. So that, of course, is a pure University of Chicago, where I come from, thinking, but you run into territorial views of the world, which still persist among all of us, and how much we really can, even though we recognize that markets operate globally, we still hold dear to our sort of territorial jurisdictions. Plus, on top of that, there is learning from a home country regulator that we can never replace. Even if the investors are U.S. investors, if the company operates in an environment that is not familiar to us, then we can only get value added. We will do a better job if we are working with the home country regulator. A key moment for us in Dodd-Frank a couple of years ago was we did not previously have the capacity to share confidential information with other regulators. We now can do that. So inspections that we may do on a U.S. firm, if they're relevant to, if they're within the jurisdiction of a foreign regulator and relevant, and they make a request, and the board can make the decision to share that information. Cross-border areas of enforcement also, this is possible. This opened up, this was a key part in gaining confidence in Europe, that we were taking a reciprocal approach. Very honestly, we went to the legislature and said, we will not fulfill our mandate and be able to look at non-U.S. firms as you have designed in Sarbanes-Oxley without this. So that is a way in which we help each other improve our home country legislation. The EU directive, so I've mentioned the 8th directive on statutory audit. We had Enron and, very frankly, WorldCom, which was our political moment to be able to create the PCAOB and Sarbanes-Oxley. Europe had a similar moment with Parmala, where there had been a draft directive floating around on establishing independent audit regulators, but it really was not able to come to fruition until Parmala. And these are some of the European regulators that we work with very closely. I think you'll continue to see more activity. We are now conducting inspections in languages other than English, which I think is a big thing for us. Spain also, first one where our board signed in English and in Spanish. Some of the other countries, so if 10 years out, you had PCAOB and Sarbanes-Oxley, you had the 8th directive growing the European regulators. In other countries, Australia, and this is another model you'll see, has their audit oversight program within their securities regulator. Italy does the same. There are many others. The Canadian Public Accounting Board, which successfully straddled the provincial-federal divides unique to that country. We all have our own. Japan actually has two ministries that oversee. Japan is interesting. We have an agreement with them, and you can find all our agreements online. They're public. But when we come in and do an inspection there, they actually prefer that we don't do it together at the same time. Every country has a different perspective. Trying to think of some of the others. Swiss. We have found our relationship with the Swiss now is very strong. What has been very fruitful for us in this relationship is that we have, as you can imagine, they have very prescriptive legal regimes, and yet we have been able to find practical answers wherever we have conflicts, and the work has happened. And so we have learned a great deal. Both of our methodologies have improved. But I think the point with that is that you can't let tough legal regimes get in the way. There is always, as long as you can define the mutual benefit, there is always a way to work those through when ultimately you have the same mandates. Oh, is that it? So last note is International Forum of Independent Audit Regulators, which you may or may not have heard of. Its acronym is IFIAR. It was established in 2006. Two key membership criteria, which goes to independence from the profession. The governing board must be majority non-practitioners, funding must be independent, and it must act in the public interest. There are 44 members right now. Some of the most tangible results for us are there's now inspections. If you look at the press release from our last meeting, we had an inspection results survey. It is striking to us as we go around the room, and the head of inspections for each of the regulators really talk about seeing many of the same persistent problems. Training, there's an annual inspections training that IFIAR puts on, which really is exchange of best practices. I'm a very strong believer, I may be a facilitator, but really where things happen is when our inspection teams work together in the field, and they have to look at the same situation but with different eyes, and they have to talk it through. GPPC, the IFIAR heads meet regularly with the heads of the 6 global networks. There is a standards working group that discusses the different proposals that are out, and we don't coordinate on comments, but learn from each other so as to improve the individual regulators' comments. I think there's been more and more push from different bodies to hear from IFIAR members now that we're sort of 10 years up and running. So with that, let me just say a couple of quick notes on those areas where I think you're going to see more cross-border work, or why we have to worry about international relationships. One is the hot-button issue of audit firm rotation, which has, observers say has a very good chance. It certainly has been made the hallmark reform by the Commission in Europe. If that is to happen, that is going to affect the firms that we regulate. Even, the PCAOB may not weigh in on it, but it will mean that dual-listed companies with engagements, those engagements are going to have to rotate. So the ones that, the U.S. firms or let's say a Swiss firm that runs the group audit, sorry, not Swiss, bad example, UK firm, would have to rotate. So it's going to be our reality. We're going to see component audits in Europe have to rotate. So maybe the group auditor is here in the US, but the component audit and significant operations is over in the EU, and that would have to rotate, forcing the company to decide, do I have 2 auditors for that component audit? One to do the local statutory audit that has to rotate, and one to do the group audit because I want to keep my group auditor. And then lastly, the wild card is under EU law, you can also designate other kinds of companies as public interest entities if they have a great nexus or impact. AIGs of the world, which normally would just be US issuers, could they become subject to rotation? So that's just, I name that just because that's an example beyond sort of the traditional inspections cooperation and even cross-border enforcement cooperation, where we have to coordinate even more closely because the effects are going to happen here even if the PCAOB is not the first mover on an issue. So I have talked for quite too long. I don't know if there are any questions that you might have.
Any questions, anyone? I have a couple.
Okay.
Let's share the microphone. In regards to foreign auditors, we've at the state level come across the problem of foreign auditors filing with the SEC on entities that are listed as U.S. companies. Has that come to your attention, and you know what the PCAOB is doing about it?
So, if an audit firm is going to file with their report with the SEC or have the company file with the SEC, they must be registered with us. If they are not registered with us, and we have had that situation, then interestingly, Sarbanes-Oxley does not give us sort of enforcement authority over them. The SEC can bring different actions. State level certainly can bring different actions. The most that we're able to do actually is deny a registration should they try and register with us. And that was definitely an interesting moment we had with a foreign regulator where this happened. And, you know, the foreign regulator said, we would have thrown the book at them. And it was really the extent of our authority, what we could do and couldn't do.
Very good. So. And then my other question has to do with the comment you made about under Dodd-Frank, you're now able to share information with other regulators. How about state board regulators?
That has always been in the PCA, that's always been in Sarbanes-Oxley. So
well, it has, but it's based on confidentiality, and we're still having some issues about whether or not, you know, some states have a problem with not being able to keep their disciplinary actions confidential.
Right.
So where are we on that?
That's interesting because we have run into, with one jurisdiction in particular, that issue where even though we reduced and showed the very little risk of a disciplinary matter becoming public in a way that would reveal the confidential information they shared with us, the very fact that minute risk existed meant that they couldn't cooperate in the same way. We just had a narrower ban for cooperation because of that. So I don't know exactly where that is. That's something I have to follow up with our general counsel. But interestingly, one of the things that foreign regulators, and you can see it in our agreements or our protocols online, what they care about is forward transfer of information. And we're very clear that, our law prescribes who it is that the board can decide to share with, and we keep that avenue open to share with the state boards. But it is something that the foreign regulators look at very closely. So.
Thank you very much.
Okay.
Any other questions?
I don't know if this is on, but I guess it is. Hi, my name's Ruben Davila. I'm from California. Just curious because you talked about the regulatory environment, kind of the structure, the focus of that, and then there's how it's designed versus how it's implemented and the resources available to regulators in a foreign country. So that's one question on how the PCAOB, their structure, and there's how it's actually implemented, how you guys evaluate that, what you guys have learned, and then I have a follow-up question. So.
Well, take that. It is a very fact-intensive process to gather the right information for the board to make a recommendation, in particular about potential reliance on a foreign regulator. But it is going through it several times, it's an extremely valuable process because our inspections and our enforcement matters are far more targeted. We have tried to build risk and data into our decision-making. I mean, I think one of the parts of the PCAOB that other regulators look at and would love to try and build is our Office of Risk and Analysis. And they're thinking, different ones are thinking about that, those that have the resources, because it just means that regulatory resources are far more efficient in doing that.
Mm-hmm.
So.
The other question I have relates to China, actually. You had a list of regulatory organizations that you deal with, and one of them was Hong Kong, and Hong Kong obviously is a gateway for listings to China, where a number of, essentially much of the operations are in China. So I was just wondering if you can shed any light what the PCAOB is doing with anything related to China. It's just such a big trading partner in both respects. So.
Absolutely. And it is a colleague of mine that is our lead on China, so I won't pretend to step into his shoes, but certainly has been a focus all the way up to the board. As you may have seen, and Lou Ferguson, who spoke here the other day, in particular, has taken a great interest and lead. Our exchanges with the Chinese have been far more robust, substantive, and regular over this last year and a half, to the point where you may have seen these are not joint inspections, but while we are negotiating a statement of protocol with them, we are exchanging observational visits. So we have the first team in China now watching their inspections. Again, it doesn't replace joint inspections, which is a necessary step before we can do confidential information sharing and before we can consider any kind of reliance. Mm-hmm. But and I think that the Europeans understand that. This board is very, very conscious about being even-handed, fair in applying the same standards when it comes to potential reliance. And doing it based on actual data and experience and confidence, because at the end of the day, the board can't delegate its responsibility to do a PCAOB inspection. And so if it issues a report, which it's required to do, it has to be confident, and this board takes that very seriously, it has to be confident that the inspection work really was done. So coming back, I think robust is the right word, and there have been recent articles going back and forth on that.
It's just interesting because you talked about territorial notions and language barriers, communication barriers, and with China, those tend to be difficult. So thank you.
No, absolutely, and I think that's the big challenge. I think that is something that we in Europe, and when I say we, I mean the Americas and Europe, can really set a best global standard, which others would want to emulate in terms of cooperation and overcoming differences, which will remain, but in an efficient manner. So, anyway.
Thank you very much.